tell the real story.
Secretary Whitehead, I'd like to introduce Bruce Berkowitz. He's one of the co-authors.
One of my board
Bruce and I work out together every day.
I think Bruce was there at a couple of our meetings that we attended in New York. Suddenly came to me.
Oh, Dick. I'm glad you're here.
Internalized that debate.
Oh, is that right?
Well, I congratulate you.
You never told me that.
You pulled it together. I think it's great.
You never asked me a single question.
I figured you would.
Get up here and talk for us.
You would have asked me a lot. See what I asked me. You ready? Any reason why you should read?
I'm going to call this session to order because we're going to try to have a summary of the report and any questions and discussion before they begin serving lunch. So we're going to try and do that in the next half hour, and rather than have people getting hungry and hungrier, we're going to move ahead, even though we're short at the head table, as well as some of the people who said they were going to be in the audience. I'm Richard Leone, president of the 20th Century Fund. I'd like to welcome you. Thank you for being here. The fund has a long tradition of bringing together groups of distinguished individuals to think about public policy problems. We kind of set a broad scope for their discussion, and then they have a certain amount of sovereignty in the way they want to proceed. And of course, if you get the right people, that's just acknowledging the fact that they're going to do it anyway. And in this case, that certainly was true. I want to take a moment to recognize the fund's chairman and vice chairman, who are both here in the audience today, Brewster Denny and Congressman Jim Leach. With that, I'm going to turn the program over to the chairman of this distinguished group, an old friend of mine and someone well known, I'm sure, to everyone in this audience, and a man who very ably guided this complicated and strong-minded group to a consensus on a great many difficult and delicate issues. So, Richard Neustadt, glad to have you.
Thank you.
Let me introduce the members of the group who are here. They keep shifting their seats, so I may get them out of order. But on my left is Walter Murphy, the constitutional historian and a general constitutional law specialist from Princeton. On my right is David Aaron, who's had experience, who's an author, but who's had governmental experience in both the legislative and executive branches, touching on these matters deeply. David, in my absence last summer, got stuck with the job of doing a working draft from which we worked and refined for the rest of our time. So I'm going to make David summarize our recommendations shortly, since he's the man who has most reason to remember them best. But let me go on with introductions. John Whitehead, who was Deputy Secretary of State in Mr. Reagan's second term, the man with the most recent experience in a relevant sense of these matters in government, on whom we relied extensively in that regard. And beyond him, Stan Turner, who was director of the Central Intelligence Agency during the administration of President Carter. And beyond him is Bruce Berkowitz, who's one of the co-authors of the underlying background paper, which you'll find printed with our report, the document from which we began our work, and which has been updated to include not only developments in experience with covert action, but developments in legislation, including the recent Intelligence Act of last August. Now that, oh, and Harding Carter. I was afraid he wouldn't arrive, but he has. And Lloyd Cutler. In that order. Harding, who in Mr. Carter's time was State Department spokesman, and Lloyd Cutler, who doesn't really need an introduction to a Washington audience, but whose government experience included a stint as White House counsel in the same administration. Now, this is a report on covert action and American democracy. What we were asked to do was look at both and consider the relation of one to the other. Covert action, although sometimes sporadically undertaken by one or another agency of our government, only became a regular activity of the American government in the course of the Second World War. The organizational mechanisms that conducted it were broken up after the war and then reassembled in the face of the Cold War between 1947 and 1951. Centered organizationally in the Central Intelligence Agency and under the charge of the Director of Central Intelligence. Covert action was initially thought to mean deniable, plausibly deniable activity by government. An activity which the responsible authorities in government, the responsible officials of government, could plausibly disassociate themselves from, and which foreign governments that might be affected could plausibly claim no knowledge of, whether or not they had any. That definition has been superseded in the course of time, and given numbers of highly publicized, mostly unsuccessful undertakings, by another definition, a statutory definition in the recent Intelligence Act. Let me just read it so we all understand what we're talking about here. Covert action is now defined statutorily as an activity or activities of the United States government to influence political, economic, or military conditions abroad where it is intended that the governmental role will not be apparent or acknowledged publicly. Nothing is said precisely about plausible deniability, and for very good reason, given the intervening experience. This was intended by Congress, as I read its reports, to narrow the definition. Walter Murphy, our constitutional specialist, in his concurrence to our report, which you will find beginning on page 16, quite rightly raises the question of whether inadvertently it may not broaden it more than Congress intended. Regardless, it is the definition which a bipartisan majority in Congress and the President of the United States have approved as recently as 9 months ago. And it's the definition, therefore, with which we begin. Now, we were asked to place such activity in the context of American democracy, of our constitutional system. And our first conclusion was, after considerable discussion, that covert action was inherently in conflict with our democratic aspirations, inherently in conflict with the thrust of our constitutional system, because inherently the secrecy intended to be involved is at odds with the accountability the constitutional order presupposes. It is the essence of our constitutional system, that each branch of government is in some degree accountable to each other branch, and that all are accountable in some degree to the public, the President and Congress directly accountable to their electorates. Activity of the sort I have just defined in legislative terms is inherently in conflict with that aspiration. Oh, that was our first conclusion. Our second conclusion was that while the Cold War has ended, and it was the Cold War that initially in the 1940s justified the renewal of these activities in peacetime. While the Cold War has ended, the future is sufficiently obscure and dangers in it sufficiently evident that we could not, in conscience, say that under no circumstances covert activities should be available to the government of the United States. On the other hand, it was the feeling of all but one of us that their availability should be tightly constrained. First, they should be pursuant to publicly articulated policy. A stronger standard than is in the current legislation. And they should be undertaken as exceptional matters, supplementing overt action and not independently of it. Beyond that, all but one of us concluded that those standards required three general undertakings. Let me just read what they are. First, that there should be procedures assuring effective executive and congressional oversight, plugging all the loopholes revealed 5 years ago by the Iran-Contra affair. And while the present legislation does a good deal with those loopholes, and so do procedures undertaken in the executive branch, by no means have all of them been plugged. We propose that they all be plugged. Second, that the President and Congress alike be attentive to the development of a broad consensus on the principles under which covert action should be undertaken in the post-war world. And broad consensus means public consensus. It means the mainstreams of both political parties. And third, that there be a reorientation of covert action away from Cold War objectives and methods, no longer reflective of compelling national interests, toward new threats and challenges that do reflect such interests, compelling national interests, and not otherwise. Now, those three broad notions are the ones that led us to specific recommendations. And I'm going to ask David in a moment to run through the specific recommendations. One member of our group felt himself unable to follow this logic that far. And instead, in an eloquent dissent, Harding Carter has proposed simply to ban covert actions of any kind in the post-war period. The rest of us felt unable, sympathetic, but unable to follow that lead. And instead, granting the risks, as Walter Murphy states, that such a ban will not be enforceable, and granting the fact that some of the dangers of the future are now visible, and granting the final fact that President and Congress have recently spoken in the other direction, the rest of us preferred to follow the course of procedural tightening, consensus building, and reorientation. To that end, we developed 8 specific recommendations, some of them with subheads. I doubt that they will sound like 8 when David offers them to you. And I'm going to ask David Aaron now, as the draftsman, to run through them in detail. Then we'll go to questions. And the questions can involve either the report or the dissents from the report. Unfortunately, the other dissenter, who had a single specific point to make, Ted Sorensen, can't be here. But David will cover its substance when he speaks to you. David.
Thank you very much. I might just stress at the outset that the fundamental question of whether or not, after the collapse of the communist empire and the collapse of the communist movement as a threat to the United States, we should continue any covert action activities, was perhaps the most intensively debated and discussed subject with the group. And a broad consensus did emerge that we should continue to maintain such a capability in the arsenal of American policy. And the reasons were, and I'd like to elaborate on them slightly before going into our recommendations, that first of all, the world does remain a dangerous place. We're faced with threats of the proliferation of nuclear, chemical, biological warfare, missile capabilities. We're confronted with the problems of international narcotics trade. There are issues of regional instability. There is international terrorism directed at the United States and our citizens. And each of these are areas in which covert action may, at some point in the future, have an appropriate role in countering. Because the international system is still a system of sovereign states. There is no international police force to whom we have recourse, and the United States must look after its own security in the last analysis. I think it also was concluded that it would be inconsistent to permit the President of the United States, as we do under the War Powers Act, to conduct military operations on his own initiative, but not undertake lesser measures such as covert action. In fact, I think most of the task force would agree with Walter Murphy's concurring view that we know too little about the future and too much about the past to think that the security of the United States will never again be in serious danger. Covert action is an instrument that should be available to the President to deal with such circumstances. Let me reiterate the 3 points that Professor Neustadt made about minimizing the conflict between covert action and the American democratic process. First of all, that oversight must be effective. Second of all, there should be a consensus on the broad principles under which covert action is carried out. And thirdly, there must be a reorientation of covert action operations towards the new threats that we face, and I'll say more about that later. Let me first address the question of oversight procedures. The Tower Commission report, National Security Decision Directive 286, and Public Law 102/88, passed by the Congress, go far to establish effective procedures for oversight. And I think that the task force felt that both the Congress and the executive branch deserved congratulations for a very difficult effort and, in many respects, a successful one as well. Unfortunately, these documents and these agreements still fall short in several important respects. First of all, and surprisingly, they failed to plug important gaps revealed by the Iran-Contra scandal only 5 years ago. Beyond that, Public Law 102/88 can be interpreted even to legitimize some of the actions in that case that were regarded as key abuses. Finally, neither the law nor the executive branch regulations say very much about the principles on which covert action should be based, and nothing about the policy objectives that it should serve. Let me be more specific about the question of oversight procedures. The first issue is the question of keeping the Congress fully and currently informed. There was, I believe, in the legislation, major progress in this area, beyond the conflicts that have existed between the executive branch and the Congress over how much the Congressional Oversight Committee should know and when. The law provides for advance notification of covert actions to the committees in most circumstances. However, in extraordinary situations, the President may limit notification to the majority and minority leaders of the House and Senate and of the two committees. In other words, he may restrict the dissemination, the notification required to 8 individuals in the Congress. Finally, the law provides that if the President does not provide timely notification of covert action operations, he must, at some future point, explain himself to the Congress. Now, timely notification has been subject to great debate between the Congress and the executive branch for well over a decade. And in the legislation and accompanying executive branch regulations, they have in effect agreed, the two sides, to disagree. There is a letter from the President, which is contained in our report, and in the conference report, page 110, Appendix E, if you want to look at it, which says that it lays out the basic procedures for notification. It says that in almost all instances, the President will give prior notice of covert actions to the committees. In rare instances, when he does not provide advance notification, he will do so in a few days, and in practice that has come to be 48 hours. However, the President's letter states that he still asserts the right to withhold notice indefinitely based on his constitutional authority. The Congress disagrees with this position, and the task force agrees with the Congress on this matter. The President and the Congress have agreed, and the task force concurs, that in some cases notification should be restricted to only 8 members. And we concur that notification may be made after the fact. But for the President to go further and to assert a constitutional power to withhold notifying anyone outside the executive branch indefinitely is, in the view of the task force, an abridgment of the accountability required by our democratic process. The task force also notes that these commitments and procedures are contained, concerning timely notification, are contained in a presidential letter. They do not have the force of law, nor are they binding on the President's successor. In the view of the task force, this should be remedied. In this connection, I want to note that one member of our task force, Ted Sorensen, dissents from this view. It is his argument, which is concisely and I think effectively stated, that in all cases there should be prior notification to the Congress of covert action operations. Finally, let me point out in regard to notification that it was one of the keys to the Iran-Contra scandal that notification of these activities were withheld from the Congress. And under the theory of constitutional authority proposed by the President, this could still happen. Another abuse revealed by the Iran-Contra events was the use of private entities to conduct much of the business of the Iran-Contra operation. In fact, there were assertions in the course of that investigation that one goal of the caper was the creation of a permanent, quote, off-the-shelf covert action capability not accountable to the Congress and possibly not accountable to the executive branch as well. One might have expected that PL 10288 would curb this practice. Instead, in view of this task force, it provides a backdoor authorization for the existence of such entities and for their use. And I would direct you to PL 10288, Section 503A4. That's on page 101 of Appendix D. The law only states that the presidential finding accompanying any covert action must specify, not identify, the use of such groups. Combined with the right to withhold the presidential finding indefinitely from the Congress, one has a formula for another Iran-Contra situation. It is the strong recommendation of the task force that the use of such entities be forbidden. Now, this does not mean that the CIA could not use proprietary organizations, as it has in the past, that it cannot conduct contractual arrangements with legitimate private or corporate groups. It does not mean that the CIA cannot collaborate with foreign intelligence services or their proprietaries. But the use of Mission Impossible freelancers, accountable to no one, should be prohibited. A third abuse of the revealed in the Iran-Contra events was the use of government agencies other than the Central Intelligence Agency to carry out covert action. In that case, it was the National Security Council staff itself. Again, one might have expected that PL 10288 would rule out such practices. Instead, we find that it spells out procedures for doing it. And there I would refer you to Section 503A3, Appendix D, page 101. These procedures would appear to apply the same restrictions and reporting requirements on other agencies as for the CIA in the conduct of covert action operations. However, it is also shot through with all of the same exceptions that I have mentioned earlier. In particular, National Security Decision Directive 286, paragraph Roman 3, which you'll find on page 93 of the book, requires that the heads of other agencies conducting covert action operations keep the Director of Central Intelligence fully and currently informed of their activities. Which means in practice, as we all know, that if the President so decides, the DCI may not be informed at all. The point that must be understood here is that the DCI is not necessarily going to be in charge of all covert action operations. This, in our judgment, can severely affect congressional oversight. Only the intelligence committees have the capability to oversee covert action operations. And, as in the case of Iran-Contra, even they can fail. If covert action is carried out by the Pentagon, or by the Treasury Department, or the Department of Energy, or the Department of State, or Commerce, or Labor, or the National Security Council staff, the cognizant committees are unlikely to stumble across it. For these reasons, the task force concluded that the DCI must be held accountable for all covert action operations by the United States government, no matter how many other agencies may be involved, no matter how they may be involved. Now, in the interest of time, let me just add that in addition to these points, the task force proposes tightening other requirements and procedures. They're set forth, I think, pretty directly in the book. For example, we would draw a tighter line on counterintelligence and cover and deception activities by the military that would have effects similar to that of covert action. If you want to get into why that's so, I'll be happy to address the question in the Q&A period. Secondly, we suggest a paper trail for objections that may be made in the executive branch to proposed covert action operations. And finally, we strongly suggest that there be a written assessment of the consequences of public exposure of proposed covert action operations so that the President and his senior advisors can be fully aware of the downside risk, which is often ignored in the course of policymaking in this area. Now, a second major area of our recommendations concern the principles by which covert action should be conducted. In this respect, the task force proposes the following. First of all, that covert action never be regarded as routine. It should be regarded as an exceptional act called forth by threats or challenges that create a compelling national interest that justify abridging the democratic process. Secondly, and I think Dick Neustadt touched on this, covert action should support publicly articulated policies, not, as in the present law, merely identifiable policies. The current law does not identify how these policies are to be identified, nor by whom the identification is to be made. Third, we recommend that covert action not be used to advance the commercial interests of individual American companies, private concerns. And we've included that because there's been a lot of discussion of how intelligence activities have to be reoriented to deal with some of our economic challenges that we face abroad. Without going into all of the details of what that might imply for covert action, the one thing that seemed quite clear to us was that to mobilize government covert action operations on behalf of individual American companies was likely to not only be counterproductive for the United States government, but counterproductive for the companies concerned as well. Finally, assassination. I'm sorry, it's not finally, but assassination, which is prohibited by executive order in our judgment, should be written into law. An example of discussion of this subject in public was the recent Gulf War, where there was many calls for action that would be taken to get rid of Saddam Hussein. Our suggestion to turn this into a law is based on the recognition that of all the leaders in the world, the American president is perhaps the most vulnerable to assassination, and we are the country that has most suffered from the assassination of our political leadership. Finally, we believe that covert action should be undertaken only when overt means are unavailable, insufficient, or too costly in terms of human life. And I would point out in this connection that overt means today are much more accepted than they were when covert action was first developed. For example, we have organizations such as the National Democratic Institute, the National Endowment for Democracy, the National Republican Institute, that are active in many areas of the world, Eastern Europe, even Russia, engaged in party building, an activity that in the past would have been considered feasible only by clandestine means. Lastly, covert action, in the judgment of the task force, needs to be refocused on current threats and challenges. At the outset, I mentioned the spread of nuclear, chemical, biological, and missile capabilities, terrorism, international narcotics traffic. In addition, I would add the aid and comfort to those who are promoting democracy, resisting tyranny, or being deprived of fundamental human rights. These objectives and challenges does not mean that there should be an open sesame for covert action. We have to continue to be extremely discriminating and selective. But let me just take two examples to point out what I mean. The proliferation of missile capabilities, nuclear capabilities, is most often a clandestine activity conducted through the intelligence services of other countries. And the response, it may well turn out, would be to use our own clandestine capabilities as well. I would, in this connection, refer you to the recent ship incident. The ship from North Korea headed for the Persian Gulf, which the Navy supposedly could not find. But if it had, under existing international law and comedy, there really was nothing the Navy could do if they had intercepted it anyway. Secondly, I would suggest that the possible use of covert instruments to support those who are fighting for democracy is not something that has disappeared with the collapse of the Soviet Empire. There have been press reports, for example, that the United States helped Solidarity in its darkest days of being oppressed and ruled illegal by the regime in Poland. Personally, I hope that those reports are true. But I think we have to face the fact that 1 billion people in Asia today still live under a communist dictatorship. And there are other dictatorships around the world, people who are suffering, having their human rights abused and deprived, for whom the only sustenance may be that provided by a clandestine means. Now, let me just conclude by saying that our deliberations and our recommendations are neither partisan, nor are they pro-executive branch or pro-congressional branch of government. In particular, I think it's important to recognize that the congressional oversight is just as important as restrictions to be placed on executive branch conduct of covert action. And I think that we have a right to be concerned about the vigor of some congressional oversight. Let me take the Iran-Contra case once again. In that case, the Congress passed a welter of laws concerning aid to the Contras, some of it contradictory. And in our judgment, some of it invited circumvention. And the administration at the time made no secret of its desire to aid the Contras. And yet it does not appear from at least the public record that there was any particular vigilance by the intelligence committees to see if that situation might have implications for their oversight responsibilities. So in conclusion, it is our strong feeling that if covert action is to be reconciled with the requirements of American democracy, vigilance will be required on the part of everyone involved. Thank you.
Thank you, David. Now, I want to turn to your questions, and I want to do it in the following double fashion. We will start by taking questions up here, and I will field them to whichever member of the committee I think you might most profitably hear from, or take them myself, one or the other. And that will go on until the service of lunch gets too noisy to be endured, at which point I'm going to release the members of the task force to go down and share in luncheon, with the understanding that we will each join a different table. That's why there's some reserve signs around. And you may then continue your questioning all through lunch of whichever member you happen to get. That way, the question and answer period will not come to an end before the whole occasion passes off in dessert and coffee. I hope there's dessert and coffee. There is dessert and coffee. Take Leon system. And the beginning of lunch and the beginning of the noise will depend entirely on the director's decision. I have no part in that. Now, let me ask for questions. If you just raise your hands, I'll do my best to be responsive. Yes, Chuck.
Dick, I think I detect what may be merely a language problem or a miscommunication. On page 7, It says, if U.S. military and counterintelligence activities had the objective of effecting major changes in the national defense policies of foreign governments, etc. Well, in the act that Mr. Aaron referred to, traditional military activities are excluded from the definition of covert action. And counterintelligence, as such, is not covert action. So what are we talking about? I noticed Mr. Aaron said that he could explain this further in the Q&A. I suspect
I was taking a risk.
I think it's military-civilian disconnect here in terms of language. I may be wrong.
I don't think there is a disconnect. Oh, indeed, I have to say that one of our members, General Willie Smith, worked very hard on that language and intended to be here today to explain it if questions were asked. But since he isn't, and David volunteered, I will let him take a crack at it. Oh, then others may wish to join in. David? You just sit down.
We can speak from here again.
Yeah.
Let's see if I can find the language in the act. Let me tell you what we're trying to deal with and what we're trying to achieve. I couldn't find the language in the act to contrast it. The effort of our recommendation, as I indicated in my presentation, was to try to draw the line a little tighter than was drawn in the act. And what we're concerned about here, for example, let me take counterintelligence first, is that in the process of counterintelligence operations, particularly double agent operations, it is not unusual to provide information to your double agent which is not true, is in fact deceptive. And it is also possible to provide information through your double agent that has an impact, an important impact, on the policies of the government that thinks he's a legitimate agent of theirs. There have, at least according to lore and legend, been occasions in the past in which such information has had an important effect on decisions made by other governments, affecting their military capabilities and indeed affecting the threats they pose to the United States. It is our intention to try to make clear that such activities in the counterintelligence field should be reviewed, should be monitored for their possible political consequences on the decision-making of of the target country, and if they are indeed capable of changing their policies in a significant way, they should come under the same reporting requirements and the same deliberative procedures. Cover and deception activities have similar potential, and if they don't, fine. But I mean, it's so when you identify the fact that this may be a problem of language, you're correct, and our effort is to make that language a little tighter.
Yes, sir.
Yes, I'm David Grease, CIA. My question is similar to Chuck's, and it goes to page 30 of the report. And it concerns a definitional matter that has troubled me for years and years, and I simply wonder whether the task force debated it or discussed it. As you will notice in the first tick, that covert action really is defined in a negative sense. That is, it is everything which is not something else. In short, it is everything which is not, does not have the primary purpose of acquiring intelligence or is traditional counterintelligence activities. Everything which is not those things is covert action. This is a little bit like saying there are speed signs posted on this highway, and you dare not exceed them, except in many places the sign hasn't been put up yet. It's very difficult to define something that way. What is a covert action? Is there in fact a clear line between acquiring intelligence and conducting covert action? I think those of us who've wrestled with this have found the line is not so clear, and that on many occasions we debate long and hard whether in fact a particular activity is a covert action.
You are reading from the background paper, yes, not the task force report, and you're raising an issue which has always been with us. We understand it. I'll let David wants to answer this question. Let me make only this general observation to start with. Members of the task force were aware that you have wrestled with that question, and that various members of political administrations have wrestled with it over the years. The thrust of what we're saying is people ought to wrestle harder, and the body English ought to be different than it has been at various times. Covert action ought to be something not undertaken, except in support of publicly articulated policy if overt action is clearly insufficient to do the job. Now, that doesn't mean people won't have to go on wrestling. We're at that gray point. But I think it was the consensus of the group that the wrestle ought to take place with a rather different sense of where the line, where one's looking for a line, than has sometimes been the case in the past. David, you want to go on?
Yeah, I might just say that in the course of our deliberations, which did extend over quite a period of time, we had developed a definition of our own, which, looking at the draft definition which was being prepared by the Congress, which, as you point out, it's sort of everything left over after the government does everything else. We thought of saying, well, why don't we turn this around and say covert action are those activities traditionally carried out by the Central Intelligence Agency for the purposes of X and so forth, instead of going through all these traditional activities being performed by the military and the State Department and the Peace Corps and whomever else might be involved. Unfortunately, the Congress went ahead and adopted that before we could make this point, so we simply dropped it from our recommendations.
Any other members of the task force have any comments at this point?
Well, I would only want to add, Dick, that it seems to me, Dave, that the sentences just before that tick are the most positive definition of covert action that we've ever had. The Hughes-Ryan Amendment, which was the previous definition, was totally anything else but, whereas you do have a pretty clear expression here, which I thought the Congress did a good job on, saying to influence political economic conditions when its intent of the role will not be apparent or acknowledged publicly. I think we had a lot of discussion in the task force about that and whether maybe it would have been desirable to be, say, not apparent or acknowledged publicly for a long period of time. All operations are secret when they start, but the question is, do you really want this one? Is it really injurious to the United States if it ever comes out that we were behind it?
Yes, sir.
David Newsom, formerly of the State Department. Clearly one of the most difficult kinds of covert action to remain deniable is the paramilitary, certainly the large-scale paramilitary activity. I know that in the past there has been some discussion of separating out responsibility for paramilitary operations from the Central Intelligence Agency and from the normal definition of covert action. I wonder if the committee gave any attention to that.
Well, we did discuss it. Does anybody here want to pick up that line of comment, or shall I simply?
Well, I could say this much. I think it's clear that the, and I'm speaking personally now, not for the task force, I think it's clear that the provision that provides for other agencies to conduct covert action that is contained in the law is primarily aimed at the Department of Defense. And because of the rivalry between the Department of Defense and the CIA, it's likely that that's the reason you have this arrangement for sort of co-responsibility which exists in the Act. Well, having not been candid about what the issue was in the law, unfortunately the law could apply to any agency of government, including the National Security Council, and this is why we identified it as a potential area of a problem.
Yes. I think I ought to move to that table now for a moment. Yeah, we'll come right back. Oh, I'm sorry.
Yeah, I thought I would just say something very quickly here, having spent those same hours with this commission. And the first thing is, there's never been as generous a group of people tolerant of the pinpricks of a guerrilla activity which repeatedly tried to fight over the same ground that had already been lost. And in that tolerance, absorbing at least some of the dissent. This is an extraordinarily knowledgeable group, as you can see from the CVs, absent me, about this subject. And frankly, dissenting as thoroughly as I do, I want to reaffirm one point in that dissent, that if this government were to accept the recommendations of this report, we would be a lot better off than we are now. My problem was that I thought that we came to examine the Old Testament and to come up with a new one in light of a changed world situation. In writing the New Testament, we reaffirmed our faith in the enduring God. I came out, of course, an atheist. It is one of the problems, I think, of all commissions, which is to ask themselves, why are we here? And I think at end of day, my concern is that we answered it. We are here to ratify that which is. I think this is an opportunity, as in so many areas of our government here in the early 1990s, to rethink practices which, after all, are not as old as a republic in their bureaucratic form, and which are as old as a republic in their assault on a number of the republic's virtues. I want to repeat, however, that my mates up here on this platform and throughout the commission have heard all this more times than they ever need to hear it again, and they heard it with great generosity.
It has to be said, however, that it was always well-spoken. Well-spoken, eloquent, and appealing. Was a question here that someone I had recognized before I realized that Hotting wished to make that comment, who put his hand down. Oh, okay.
I wonder whether, in considering this recommendation, the Commission considered the likely practical consequence of having a covert operations capability in effect. That is, I think, the history of this, and we were told we needed to look at the history as well as the future, is that if you have such a capability, and if in principle it is sanctioned, it will be used in a vast number of cases which do not meet the criteria that are laid out by the Commission, simply because the executive branch will assert, whatever the criteria are, that they are met. And so the recommendation is one that, as a practical matter, it seems to me, the history shows, simply cannot be accomplished.
Nice to see you.
Well, I think that argument applies equally. Indeed, most of us, I believe, think it applies more strongly to the notion of a ban. The central idea of this group, and I'll state this and let my colleagues respond to it, is that in a very large government with very diverse capabilities, and many of them, not all of which are going to be disbanded, no matter what the legislative specification may be in general. The best safeguards are those which stem from procedure coupled to oversight. Procedure involving both branches of government and oversight involving both branches of government. Shared responsibility and shared authority between President and Congress. Now that implies a spirit which Mr. Bush, for one, has been prepared to, apparently, on the public record to offer in practice but not in theory. Only administrations that are prepared to acknowledge, first, the importance of accountability, and second, the sharing of authority, are likely to be held in check by whatever we come up with. And I think we understand that. What we're saying is procedures of shared oversight, continuous attention to the oversight, a narrowing of usage to the minimum consistent with our two requirements of supporting publicly articulated policy, and supplementing overt action, which is always to be preferred first. If you get public officials not prepared to respect such procedures and such generally held ideas, then you're likely to have trouble. I mean, you can't legislate perfection. But we think that if Congress were to enact and administrations were to enact the additional procedural safeguards we suggest, and in the process recognize their joint responsibility, and that became the tradition in which this government operated, you would not have what you're talking about. Anybody want to elaborate on that?
Mort, if you impute that much malevolence to the executive branch, then you have to impute that if there were a ban on covert action, they'd avoid it too. And we think controlling it is a better course.
That was, of course, debated. The counter-argument, of course, is that once having established, let us say, that murder is okay under certain circumstances, you automatically introduce the idea that murder may be okay under a number of circumstances. If you say murder is not okay, it at least is understood to be that which might fall under edict. It is always available for expansion once it is tolerated in partially.
I want to, though it's fun, I think my task here is to move to questions of, we can come back around to the issue at lunch. Yeah.
I'd like to agree with, I think, a main proposition of Harding Carter, but I guess I didn't become an atheist. I came to believe in another God. But it seemed to me Harding Carter touches on a point, and I'd be interested in the rest of the task force's response. Basically, the committee, this task force, the way you've described it, and we've only had, of course, a few minutes to look over the findings and so on. Basically, though, this seems to be the consensus that existed at the time of the Church Committee and the immediate period after the Church Committee. Although some of the propositions or recommendations are slightly updated in a modern context. Obviously, there was a post-Cold War period that wasn't present then, and some other oversight provisions which weren't present in 1975-76. Basically, if I understood what Harding Carter is suggesting, is basically you've come to the same position that you came to in 1975-76, or at least the country did at that time, at the time of the passage of Hughes Ryan, subsequently amended the Carter administration's EO 12036 and so on. But basically you've come to that same position, and if I understood Carter's position was basically saying, no, we should be coming to another kind of position. Now my question really is, first I'd like to know if that's correct. Have you actually, has there been an evolution in the thinking about this subject since 10 or 15 years ago, when that sort of the consensus was formed about the oversight regulations and the principles that guide American covert action, which I think you're pretty consistent with? But the second question is, did you consider taking up other questions, such as what makes for effective covert action? You grant that sometimes it's necessary, although albeit you want it to be very limited. But it seemed to me one of the things the Church Committee didn't take up, and what one of the things the country has not studied, is what makes for effective use of this instrument other than making it compatible with American values.
Well, let me come to that second. Ask David, who was observed this for the Church Commission, whether he thinks there's been an evolution.
I think there has been an evolution, and I think there's been an evolution both in the executive branch and in the Congress. We now have major congressional intelligence committees that are experts who have deep contacts within the intelligence community, who are capable of following all of the arguments, know the issues backwards and forwards and so forth, which makes for a very different kind of relationship. I think people would say, perhaps not happily, that the Director of Central Intelligence works as much for the intelligence committees as he does for the President of the United States. And sometimes that's considered by some people as good and by others as bad. I think that the abuses that one saw in the Iran-Contra case were examples of efforts to get around the very controls and procedures that were established on the basis of the Church Committee findings and the regulations and so forth that were established afterwards. And it got them into trouble. And I think that we, in some respects, had to relearn the lessons of the Church Committee. But we also had to update them because we had to look at different ways of proceeding, such as the use of so-called private entities that have no responsibility to anyone, or the use of agencies not traditionally involved in covert action activities. And I might just say, by way of explanation, in my reference a moment ago to the Peace Corps didn't suggest that they've ever been involved in anything like that. It was entirely facetious. But I think those kinds of steps on the part of the executive branch to wiggle out from under these restrictions suggest that we have a continuing process here. I mean, this is not a cat and mouse game, but it's an iterative process in which we try to refine this instrument. And I think that our conclusions also, I hesitate to say this, but I'll assert it, and maybe I'll be contradicted. I think the task force also basically concluded that the extent of covert action activity by the United States government in the current political circumstances ought to be really quite small. That this is not something that that would be a broad-scale activity as it existed in the past decades.
Let me simply make two further observations. I think the fundamental difference between Harding's position and that of the rest of us is that Harding concludes there's no learning process. It's going to get the appointive subordinates of elected executive officials together with congressmen selected for the intelligence committees and their staffs to honor the plain logic of the Constitution of the United States with respect to shared authority, accountability, and responsibility to set procedures. I think the rest of us are still working on the notion that if you get the procedural context right, which we don't think has been done adequately up to now, the very process of getting it right and achieving a public consensus on what covert action should be used for, redirecting it away from the Cold War, that those processes themselves might give you the kind of responsibility on the part of both executive and legislative officials that's wanted. Harding doesn't believe it. We are hopeful of it. And I think I can speak for the rest of us in saying that we think the evolution since the Church Committee is an evolution. including the work of this task force, including the degree to which we, although having served at very different times and for different administrations of both parties, can come to something of a consensus. Now, the other thing the only thing I'd like to add with respect to your second question is that one of our recommendations, that for the sake of public accountability in its broadest terms, we think the Central Intelligence Agency, in cooperation with the congressional committees, should undertake a detailed review of the experience with covert action from the beginning, weighing precisely the questions of effectiveness and ineffectiveness, should make a declassified version public, and should reiterate the process perhaps once a decade or so. In the absence of that, no group of people, however informed by particular past experiences, can do it. And we were sensible enough to understand we couldn't do it, so we didn't do it. But we think that should be done. Anybody else want to add here?
Yes, there is just one notion here I want to add. That is an exact statement of my position, which I can only think of as the deep Southern position, which is to say the extremely conservative position, which is a reading of man, which is just at odds with the Commission's reading. Yes, I do believe that given the opportunity to do wrong, we will do it, and particularly if we are already told it's not wrong.
Any other questions here? Yes, sir.
I have a question about how substantive the criteria for covert action are that you put out. And not in the sense that whatever standard you have, the administration will decide that it's been met. But your first one is that it has to be in support of articulated policies. The last time this was debated, or in Congress, I said consistent with articulated policies. But you could have something that's in support of articulated policies that's inconsistent with it. So I wonder whether substantively that's a restriction.
What is in the present legislation is consistent with identifiable policy. Nothing is said about who identifies. Now, in my view, Ronald Reagan was perfectly capable and probably did, in his own mind, identify as policy. Both the form of aid to the Contras that his administration undertook, and the military assistance to Iran. That's the distinction we're trying to draw.
Support of rather than consistent with.
No, I'm talking about the difference between identifiable and publicly articulated.
The other thing is just how realistic is it to think that covert action will only be used, as you say, as a supplement to overt action? I mean, in effect, you're presuming that the government should try everything it can overtly and make sure that it's failed before it does a covert action. And realistically, is that the way the government's ever going to do it if they think something's worth achieving?
In addition to failure, we talk about cost, and I'd like David to reiterate that point. I think it's important.
Yeah, the language is, let's see if I have it here. The language is when overt means are unavailable, insufficient, or even if sufficient, judged too costly in terms of human life. This is not, a terribly stern test, and it's one that policymakers, in our judgment, need to apply. Too often, in my experience, and I'm sure of others in this room, covert action has been turned to because there was a desire to don't just stand there, do something. We've got to show that we're trying to do something. That, in our judgment, is really the worst possible reason for doing this. And I know that people in the agency who have to carry out these do-something orders find it pretty appalling as well. So this language here is simply to make the point that there are other alternatives, that they ought to be considered very carefully by policymakers, and indeed, as sort of preambular statutory language, it seems to us to be a very good principle to implement. Now, is this practical? Will they do it anyway? Well, I can't tell you, but I can tell you that if it's written in law, you've got people like Harding who will sit around the table and say, "Hey, wait a minute, this doesn't strike me as something that we can't do in some other way."
Now,
just so I understand, normally you don't know in advance whether overt means will. You don't always know in advance whether overt means will achieve your objective. Do you mean that you should try them and see whether they work first?
No, I think you make your best judgment. I mean, what we're talking about here is that, for example, is that you can achieve some of the things that covert action attempts to achieve by military action. But the cost in terms of human life would seem to be disproportionate to the objectives involved.
Now, it's been pointed out to me that some members of this task force find it very difficult to watch all that food going over there and not being able to have any. So I'm going to rule that at this juncture we move to our fallback position, and if all members of the task force and Mr. Berkowitz will please join different tables, you can then carry on the inquisition as long as you like.
Members of the Task Force on Covert Action and American Democracy held this Members of the Task Force on Covert Action and American Democracy held this news conference today to discuss their report on the role of covert action. Members of the task force called for new rules for covert action in order to reduce tensions between the executive and legislative branches of the federal government. The task force was sponsored by the 20th Century Fund, a nonprofit organization that supervises research on economic, social, and political issues.